More people are coming for planning that are married but separated. These people have been married for 30, 40 years, but for whatever reason, they're living in different households, they're separated, they're no longer in what is traditionally a committed relationship. They want to do planning. So the first thing we have to talk about is, do you have a prenuptial agreement? Because most of the time they do not want this former spouse to inherit anything. They're planning for their children. Is there a postnuptial agreement that excludes this person from your plan? Because there is an elective share. So the spouse can elect from the disposition or distribution that you set up in your plan. So what that means is, if you are married, you plan for, let's say, 2 adult children, not thinking about this spouse, this person could come out of the woodwork upon your passing and say, I am the spouse and I'm entitled to inherit at least a third of the estate. I have actually seen where in this case, this person's 1/3 is the entire estate. So that left the children without the ability to inherit anything from their parent. I know we listen and we don't judge. I'm not saying you need to get a divorce or you need to do something, but perhaps if the idea is that the spouses are going to separate, perhaps at that time of separation, if we intend it to be a long term and for whatever reason we don't want to get a divorce, perhaps thinking about considering an agreement that excludes one from another from each other's estate.